Hi, everybody, and welcome to our module on confidentiality. Confidentiality refers to the fact that healthcare information is considered what's known as privileged and private. This means that providers have a duty to respect the privacy of their patients and keep patients' healthcare information confidential. For this reason, disclosure of patient information is limited to a very narrow set of circumstances. HIPAA stands for the Health Insurance Portability and Accountability Act, which was passed in the United States in 1996. And this is the law in the United States that sets national standards for protecting confidentiality. It identifies what is protected health information and what can and cannot be disclosed. The major fundamental principle of confidentiality is that patient information should be disclosed only with patient permission. Your patients will tell you intimate details about themselves, like their medical history, whether they smoke or use drugs, their sexual habits, and you need to keep this information private and confidential unless the patient gives you specific permission to share it with others. And they will test this heavily on your USMLE exam by giving you scenarios where someone wants you to disclose information about the patient, and usually the correct answer is to not disclose the information unless the patient gives you permission. So, for example, this includes the patient's spouse and children. You need the patient's permission before you share information. You don't know whether that patient wants information shared with their wife or husband unless they give you permission. This also includes other doctors. You need to obtain a release of information first before you reveal information about your patient to other physicians. This also includes government authorities. If someone from the government shows up at your clinic and asks for patient charts, you don't disclose patient information unless a court order has been issued. And this is a very important tenet in the U.S. medical system. Confidentiality always needs to be protected. There are just a limited number of exceptions, and we'll talk about those in the next few slides. One of the exceptions is that you may tell family members a patient's location in the emergency room or hospital without specific permission from the patient under certain circumstances. Hospitals are allowed to maintain what's known as directory information. This is basically a list of the patients that are in their facility and where they're located and their general health condition. The directory has no other specific medical information like what the patient's being treated for or what doctor is treating them or how they're being treated. So this limited directory information can be disclosed to a family without permission from the patient if the provider deems it in the patient's best interest. So for example, if the family of a patient arrives at the emergency room and they want to know if their loved one is in the emergency room and they have information about the patient, like their medical history and the medicines that they take, it may be in the patient's best interest to let that family know that their patient is in the emergency room, and it's okay to go ahead and do this, even if the patient hasn't given specific permission. Another exception to confidentiality is that a provider may break confidentiality if there is the potential for harm. There are a number of scenarios in which this principle applies, but in all of them, what you want to do is think about the fact that if a third party is not warned, what will happen? If definite harm will occur, then the answer is usually to inform others and break confidentiality. The reason you can break confidentiality when there is a potential for harm is because of a famous U.S. court case called the Tarasoff case. This was the case of Tarasoff versus the Regents of the University of California. It took place in 1976 in the United States. In this case, a woman named Tatiana Tarasoff was killed by her ex-boyfriend, and her ex-boyfriend was being treated by a psychiatrist at the University of California. The boyfriend stated to the psychiatrist that he intended to kill Tatiana Tarasoff, and the psychiatrist actually notified the authorities, but not Tatiana Tarasoff herself. After she was killed, there was a court case, and the result of this case was that providers have the duty to warn patients and others if there is the possibility of harm. So there are a couple of clinical circumstances in which the duty to warn and protect allows a provider to break patient confidentiality. The first one is in a psychiatric patient intending harm to self or others. This is just like the Tarasoff case. So for example, if a patient explicitly says that they are suicidal and going to harm themselves, you may break confidentiality to notify the family. If a patient says that he is going to kill another person, you also may notify the police or even the victim who is in danger. The second place where the duty to warn or protect is often applied as a reason for breaking confidentiality applies to patients who have sexually transmitted diseases. When you are treating patients with STDs, you have a duty to protect and warn the partners of those patients. This is often applied to the partners of patients who are HIV positive, but it can also be applied to the partners of patients with other STDs. This duty to protect and warn only applies to the sexual partners. It does not apply to other individuals. You do not have a duty to warn coworkers of a patient with an STD, and you cannot break confidentiality to tell the coworkers of a patient with an STD. It also doesn't apply to the students of a school teacher or the patients of a physician. When a physician is treating a patient with an STD, the physician may disclose the STD status to the partner and may do so without the patient's permission or consent, but only under special circumstances. First of all, the physician has to make a reasonable effort to encourage the patient to voluntarily disclose on their own. Second, the physician has to have a reasonable belief that the patient will not disclose the information themselves. And third, disclosure has to be necessary to protect the health of the partner. If all three of these criterion are met, then the physician may disclose the STD status to the partner, even if it is without the permission of the patient. Now, importantly, in terms of board questions, the first thing you always want to do when a patient has an STD is encourage them to voluntarily disclose. Only if they absolutely refuse and all of these criterion are met can the physician disclose without the patient's permission. And then finally, some states have what's known as partner referral services. These allow patients to anonymously inform their partners without telling them themselves. And if you want to know more about this, some of the best information is found on the web at aids.gov. This carries lots of information about how to inform partners and protect people from the spread of the HIV virus. Now let's talk about reportable illnesses. U.S. states mandate that certain diseases are called reportable diseases. Most of these are rare infectious diseases that can lead rapidly to outbreaks. The goal here is to prevent infectious disease outbreaks, and most microlabs in the U.S. have protocols that automatically report to state governments if they make a diagnosis of certain rare but dangerous infectious diseases. So these are things like tuberculosis, syphilis, gonorrhea, childhood diseases like measles and mumps, and there are many other diseases that vary by state. I've listed a website at the bottom of the screen where you can look up what some of the reportable illnesses are by state in the US. But the point here is that you don't need the patient's permission to report this to the state government. If a microlab makes a diagnosis of measles, which is very rare in the US, they automatically report that. They don't need the patient's permission, and this is done so that the state can prevent a measles outbreak in the community. Abuse is another circumstance where you can break confidentiality and report information about a patient without specific permission. In the United States, child and elder abuse generally always has to be reported to authorities. In terms of child abuse, reporting is mandatory in all U.S. states, and for elder abuse, reporting is mandatory in most U.S. states. In most cases, you report this to Child Protective Services in the case of a child and Adult Protective Services in the case of elder abuse. The way this is usually presented in a board question is it will be a child or a frail elderly person who reports to the emergency room or their physician with repeated suspicious injuries. Now, importantly, in terms of board questions, the first step is always to interview the child or adult alone. The person who is abusing them may be present when they come into the emergency room or when they come in for evaluation. What you want to do is get the person alone so that you can obtain information. The way you usually do this is by asking the person who is with them to please leave so that you can examine the patient. And in these cases, the physician is protected even if they report abuse and it proves incorrect. If you have reasonable suspicion of child or elder abuse, you can report it to the appropriate authorities and you don't need permission from the child or the elderly person. Spousal abuse is a little bit different. Spousal abuse is what's known as intimate partner violence. This is when a husband or wife is abusing their spouse. And this is also suggested by multiple presentations for medical care due to recurrent injuries or accidents. In this case, the victim is an adult and has the right to protect their health information. So what you want to do in these cases is focus on the safety of the victim. The provider should be supportive, and this is often important in board questions. You want to offer supportive words to the patient who may be being abused. This may be a difficult topic of discussion, so you don't want to press the patient to disclose information. The thing you want to do here is to ask if the patient feels safe at home, and you want to make sure they have a safe place to go in an emergency. I've bolded this because this is often the correct answer in a board question. These patients have the right to go back to the home of the person who is abusing them, and they may not be ready to leave yet. So what you want to do is help them to identify a plan. If there's an emergency, make sure that they have some place to go. There are some states that have reporting requirements, but not all, and you do not, in most cases, mandatorily have to report spousal abuse the same way you do for a child or an elderly person who's unable to protect themselves. I'll finish this module by talking about driving. So physicians often encountered impaired drivers. These are often elderly patients with vision and mobility disorders who still drive a motor vehicle every day. What you should know about this is that there's no uniform standard for reporting, and the rules on whether or not you should report this to the authorities vary widely by state. So the best answer is often to discuss the situation with the patient and family and see if you can convince the patient that it's unsafe to drive rather than reporting them to the authorities. The one exception is seizures. When a patient has a seizure, most states require a seizure-free interval before that patient is allowed to drive again. The idea here is that obviously if the patient has a second seizure while they're driving, that could be a danger to the public health. Often the seizure-free interval is 6 months, but sometimes it's 1 year. And in terms of board questions, the correct answer often involves consulting with the State Department of Motor Vehicle to determine when it is safe for the patient to drive again. And that concludes our video on confidentiality.